morning. On the syllabus, there was another person who unfortunately couldn't make it and gave his highest recommendations for Dr. Korey Hughes, who is, the course that you teach, I would be the worst student in all of your classes, and I should take your classes. Korey received her PhD from the CUNY Graduate Center, which is a little bit in Midtown. And she teaches right now at Baruch College, which is still is one of the elite 4 years, part of the CUNY system. And she teaches classes such as Introduction to American Government, Congress, Constitutional Law, Public Opinion, Women in Politics, and also leads a capstone seminar so this is more a class for advanced students to take their own interests in American government, and most recently a class on American conservatism. So that sounds awesome and dually perhaps horrifying, but awesome.
Oh, what a time it was to be teaching it.
Yes. I think that there's people and this group is actually unique, where usually in years past, the Maya scholars, a large majority of them are language instructors, but this year I feel like there's a number of you who teach culture, history, politics, and so maybe not so formal, like going around a circle and being like, hi, this is me, but definitely during the questions, you can self-identify as saying, my research interests particularly are about politics, American, whatever, modern, whatever, just to kind of increase the dialogue. So on that note,
thank you.
Have the tour.
Well, good morning, everyone. Very excited to be here. We're in the air conditioning, talking about the constitutional basis for individual liberties, which is the title of the talk, and I'm just going to start by outlining where I'm going to be going over the next 40 to 45 minutes. So I'm going to start by talking about the debate around the Constitutional Convention and when the ratification of the Constitution was debated about whether or not the Constitution should have a Bill of Rights or not. Because I think when we think of individual liberties, I'm sure our mind immediately jumps to a lot of the individual liberties protected in the Bill of Rights. But the adoption of a Bill of Rights was very controversial. So we're going to talk about the controversy over whether America should have a Bill of Rights. When it comes time to draft the Bill of Rights, we're going to talk about where James Madison specifically drew his inspiration when writing the Bill of Rights. But then we're going to jump ahead to the 14th Amendment. And I'm really going to talk about the 14th Amendment to the Constitution for the second half of the talk, because we are incredibly reliant upon the 14th Amendment to guarantee the liberties contained within the first 10 amendments. As we're going to learn, the Bill of Rights, even though it was ratified by 1791, it was not really enforced until the 20th century for reasons we're going to discuss. So let's get into the Constitutional Convention. So towards the end of the Constitutional Convention, George Mason, who was a delegate representing the state of Virginia, introduced the idea that the Constitution should have a Bill of Rights. And he argued, many of our state constitutions have a Bill of Rights. Our national constitution should have a Bill of Rights as well. This motion of his was seconded by Elbridge Gerry, a delegate from Massachusetts. So once Gerry seconded the idea, it was put to a vote from the Constitutional Convention. And their motion to at least even discuss a Bill of Rights was swiftly and unanimously rejected. Within the space of a few minutes, every single member of the Constitutional Convention shot down the idea of a Bill of Rights. Now, some of their objections were strategic, because this is September 1787, by then, both Mason and Gerry had communicated their significant reservations about the Constitution. And in fact, Mason and Gerry would be two of the three framers who didn't sign the Constitution when it was done, because they had such strong reservations. So their idea to include a Bill of Rights was dismissed by some as a stalling tactic. You're only doing this because you don't want the Constitution to be ratified at all, you don't want us to finish the Constitution. So part of the objection to the Bill of Rights was strategic. The idea that debating a Bill of Rights would uncomfortably delay ratification. However, there were also kind of deeper philosophical objections to the very concept of a Bill of Rights. So James Madison, the man that we now think of as the father of the Bill of Rights, was initially opposed to the idea. And one of the reasons why he was opposed was he called the Bill of Rights a mere parchment barrier. And what he meant was, if you have a leader or a government who is intent on infringing on your individual liberties, a Bill of Rights is not going to stop them. A mere piece of paper is not going to constrain the actions of a leader or a government who wants to infringe on your powers, on your liberties. So one of the arguments against a Bill of Rights is that a Bill of Rights would not actively limit government power. Another objection to the Bill of Rights was the idea that the Constitution as it existed without the first 10 amendments already acted as a protector of individual liberties. So the argument was, well, without a Bill of Rights, the Constitution has the writ of habeas corpus, which protects you against indefinite detention. Without a Bill of Rights, the Constitution has a ban on noble titles, a ban on religious tests for holding public office, a ban on ex post facto laws or bills of attainder. So the argument was, the Constitution already protects individual liberties in a lot of ways without a Bill of Rights. Also, the structure of the government itself would protect individual liberties. And the diversity of the American public would protect individual liberties, which are theories that Madison expands on in Federalist 51, Federalist Paper 51, and Federalist Paper 10. So in Federalist 51, where Madison is defending the separation of power system, and why America should have a separation of power system that disperses power between the three branches of the federal government and the federal and state governments, Madison argues that this dispersal of power protects individual liberties because no one branch of government will become powerful enough to violate your individual liberties. And the federal government in particular will be limited to its clearly enumerated powers. So the argument was, just don't give the federal government the power to say, infringe on freedom of the press, and they won't take it. The federal government will be limited to the powers specifically enumerated to it in the Constitution. So as long as you create a government of limited powers, where you don't enumerate powers that infringe on individual liberties, they just won't be infringed upon. If this argument sounds unrealistically naive and idealistic to you, it also sounded unrealistically naive to a lot of people, even in 1787. And even later in Federalist 51, Madison famously says that in our government, ambition must be made to counteract ambition because not all people elected to government will be angels. So you must pit them against each other. and give them and have one branch be able to check the other branches. That way, if one branch is controlled by an unsavory element, you have the other branches of government, in theory anyway, to check them. So there was this argument that the Bill of Rights is not necessary if you have a system of government that disperses power the way our government would under the Constitution. So you have this idea that the separation of powers protects individual liberty. And the idea that the diversity of the American population would protect individual liberty is expanded upon in Federalist 10, which deals with what the founders referred to as the problem of faction. So a faction is any group of people with a common interest who are opposed to any other group of people. So political parties are factions, interest groups are factions, class groups are factions, ethnic groups are factions. And the anti-federalists who opposed ratification of the Constitution believed America was too large and too diverse to be governed democratically. And I always say that, man, I wish reincarnation was a thing so we could resurrect some anti-federalists who thought that 13-state America was too large and too diverse to be governed effectively. 10 seconds of 50-state America, and I don't even know what they would do. So one of the biggest criticisms of the government created under the Constitution that the Federalist Papers are responding to is the idea that America will just be too large to govern effectively, and that Americans will inevitably and naturally have such different interests, such strong, deeply rooted differences, that eventually the country is going to collapse into civil war and break up into like multiple subunits, or you're going to have tyranny of the majority because the majority is going to say, we must ruthlessly stamp out any and all factions. So one of the biggest criticisms of the Constitution was, how are you going to govern a country that's this different when your people are not going to be unified about anything? There's not going to be a national, uniform, American attitude about anything. There's going to be the New York attitude, the Virginia attitude, the Georgia attitude. And the proponents of the Constitution granted that this was true, and they granted that America would be a country of lots of factions, of lots of different groups of people disagreeing with each other about virtually everything. But first, they said that this is inevitable in a free society and there's nothing you can do about it. So they memorably used the analogy that to try to quell faction is the equivalent of fighting fire by removing all the oxygen in the environment. Yeah, you'll get rid of the fire, but everyone's gonna die. So you can't get rid of factions without severely curtailing individual liberty. So what you do is you construct a system of government where lots of factions have some power, but no one faction has all the power. So the argument that the founders advanced was that lots of different groups of people will have some power in the American political system, but no one group will have all the power. And there will never be tyranny of the majority because there won't be cohesive majorities around a lot of issues. So actually, having a diverse country with lots of factions might work as an anti-tyranny measure because nobody's going to agree with each other sufficiently to build this kind of tyrannical majority. So these arguments, again, say both the diversity of the American population and the structure of the American government protect individual liberty sufficiently, so you don't need a Bill of Rights. And in Federalist 84, Alexander Hamilton actually goes further and says a Bill of Rights is actively dangerous because if we draft a Bill of Rights, everyone will assume it is the definitive, exhaustive list of individual liberties, even though it's not. So now, for instance, in 2018, the Supreme Court recognizes multiple individual liberties that are not anywhere in the Bill of Rights, but are nonetheless considered what the Supreme Court calls fundamental rights. And these individual liberties, which are not in the Bill of Rights, but by now the Supreme Court has recognized, include the right to marry, the right to procreate and parent your own children, the right to travel freely within your own country. Now, Hamilton argued, if you write a Bill of Rights, everyone is going to look at this and say, okay, this is the sum total of rights protected, and nothing else will be protected. So he was worried that the Bill of Rights would be used to stamp out any discussion of individual rights. So you have all these arguments against the adoption of the Bill of Rights. But if you guys, with your 2018 perspective, don't find these arguments very convincing, you are not alone. And a lot of states, when it came time to ratify the Constitution, said, we feel very uncomfortable ratifying this without a Bill of Rights. We need a Bill of Rights. So even though the Constitution was ratified without a Bill of Rights, by 1789, in the very first Congress, there is strong political pressure to draft a Bill of Rights, which James Madison, remember initially the Bill of Rights is a parchment barrier only. By 1789, James Madison has been convinced of the utility of the Bill of Rights, and he is spearheading the drive to write a Bill of Rights. So this process begins in Congress in the summer of 1789. Now, Madison's draft of the Bill of Rights started with a preamble which talked about natural rights, the concept of natural rights, that your individual liberties are not given to you by your government, but you have them by virtue of your humanity. So it's not as if you have these rights because the government gives them to you. You have these rights because you are a person, and it is the job of a just government to respect these rights. So he starts with that preamble. His preamble also says that every American has the right to life, liberty, property, and happiness. So kind of modeling language of the Declaration of Independence. He also includes in his preamble the idea that if our government is unjust, Americans have the right to alter or abolish their government if it is unjust. So he writes this preamble. The first draft of the Bill of Rights had 17 amendments, some of which were later combined. One of them was part of Madison's draft of the Bill of Rights, part of the final draft, but it wasn't ratified until 1992. So one component of the Bill of Rights was open to be ratified for 200 years, which just goes to show you persistence. Never give up on your dreams. So Madison and his colleagues in Congress work on this 17th Amendment Bill of Rights. It goes to the Senate. The Senate cuts a lot of his preamble, merges a few things together, gets it down to 12 amendments. Now, if we're looking at where the founders were drawing their inspiration, if we're looking at English sources of the inspiration for the Bill of Rights, you have the Magna Carta, or I should say really how, and at the time, contemporary Englishman Sir Edward Coke interpreted the Magna Carta. His kind of more individual liberty friendly spin on what the Magna Carta said, as opposed to what the Magna Carta actually said. So the Magna Carta, the English Petition of Rights, and the English Bill of Rights. And from these English documents, we get things like the due process rights. The English Bill of Rights contained a right to bear arms. The takings clause, which means that the government cannot seize your property under eminent domain without compensating you accordingly. Right to a speedy trial. So these are some of the things we get from English inspirations for the Bill of Rights. Then we have a lot of colonial American inspirations for the Bill of Rights. So colonial charters, state constitutions. Actually, there's one document called the Massachusetts Body of Liberties from 1641 contains within it about 2/3 of what would eventually become the Bill of Rights. Also, George Mason from Virginia, the first man who introduced the idea of a Bill of Rights at the Constitutional Convention, would be very happy to note that the Virginia Declaration of Rights heavily represented in what became the Bill of Rights. So, by September of 1789, we have these 12 amendments to the Constitution, which are being sent out to the states for ratification as the Bill of Rights. By then, Madison's entire preamble is gone. So, sorry about the preamble. And by 1791, 10 of the 12 amendments to the Bill of Rights have been ratified. The 11th, as I mentioned, was ratified in 1992, the most recent constitutional amendment, and then the 12th, never ratified. And I can say probably never going to be ratified, but who knows? 200 years from now, maybe it could. So by 1791, we have the Bill of Rights has been ratified. However, after that, the Bill of Rights went into a period of what the historian Gordon S. Wood called judicial dormancy. And the way he put it was that there was all this enthusiasm for a Bill of Rights, and during the Constitutional Convention, during the first 4 years of American government, there was this broad-based enthusiasm for a Bill of Rights. And then, as soon as the Bill of Rights was ratified, everyone shrugged their shoulders and forgot about the Bill of Rights till the 20th century, basically. So all of this enthusiasm for you must protect our individual liberties pretty much dissipates when the Bill of Rights is actually added to the Constitution. And Richard Lubunsky, who wrote a book about James Madison and the Bill of Rights, identified 3 primary reasons why the Bill of Rights was practically a dead letter, constitutionally speaking, until the 20th century. And the first point he mentioned was the absence of what he called a culture of tolerance. And what that meant was, it's really easy to support individual liberties in the abstract. It's difficult to support it's much more difficult to support individual liberties when dealing with actual specific political controversies. And he used as an example of this the Sedition Acts of 1798, where he said, okay, First Amendment guarantees the right to freedom of speech. Everyone supports freedom of speech in the abstract, but 7 years after the ratification of the First Amendment, Congress passes the Alien and Sedition Acts. And the Sedition Acts made it illegal to oppose or resist actions taken by the U.S. government.
So what is the name of that?
The Sedition Acts, and it's 1798. It's usually talked about as the Alien and Sedition Acts because the first part of it deals with immigration. So the Sedition Acts made it a crime to oppose or resist the U.S. government or to print false or malicious information about the president or about members of Congress. However, you could trash the vice president all you wanted under the Sedition Acts because John Adams was totally fine with people trashing Thomas Jefferson, his vice president and bitter political opponent, because in the very early days of American elections, the runner-up to the presidential election became vice president. So just imagine Hillary Clinton being Donald Trump's vice president right now. And that was kind of the relationship between Thomas Jefferson and John Adams. I mean, these men, by the time they actually had to govern each other, the level of personal animosity was pretty high. So one reason why there was this significant delay in actually protecting the individual liberties protected by the Bill of Rights was this lack of a culture of tolerance. I haven't even scratched the surface of whose individual liberties are not protected at all under the Bill of Rights, because we're getting there when we talk about the 14th Amendment. The second reason why we have this delay in the actual enforcement of the Bill of Rights is in the 19th century, the Supreme Court just didn't hear a lot of cases about the Bill of Rights. Most of the Supreme Court's docket in the 19th century was focused on federalism issues, balance of power issues, and they weren't getting a lot of Bill of Rights cases, and the few that were being petitioned to them, they chose not to hear. So the Supreme Court just didn't pick up a lot of cases that directly impacted the Bill of Rights. The third reason for this delay in the actual implementation of the Bill of Rights is that when drafted, the Bill of Rights only applied to the federal government. So the Bill of Rights did not constrain state or local governments in any way. So this meant the state of New York didn't have to honor any of the individual liberties protected under the Bill of Rights. And the process of incorporation, the process of applying the 14th Amendment to the state governments did not begin until 1925. And it's a process that's been ongoing ever since. Now, talking about incorporation, this is a good time for me to pivot to that 14th Amendment conversation I promised at the beginning of the talk. So, the 14th Amendment was ratified in 1868, and the purpose of the 14th Amendment was to eliminate racially discriminatory laws passed in the immediate aftermath of the Civil War, known as Black Codes. And the purpose of the Black Codes was to basically recreate the institution of slavery in everything but name in the immediate aftermath of the Civil War. So, under the Black Codes, if you were a newly freed slave, you could not travel freely, you could not own property, you could not testify in court, you could not own firearms, and you could be thrown in prison for vagrancy if you were unemployed at any level. And this meant that newly freed slaves were forced into very punitive labor contracts which were not dramatically different than slavery. So Congress passes the Civil Rights Act of 1866 to address the Black codes. However, it became quickly apparent to the Republicans in Congress that a mere law was probably inadequate to deal with this level of discrimination, and a constitutional amendment was necessary. So the Joint Committee on Reconstruction in Congress formed to write what is now the 14th Amendment. And even though this committee produced dozens of drafts of the 14th Amendment, we really owe the language of the text primarily to one author, John Bingham, a Republican from Ohio. And he made the very fateful decision to change the anti-discrimination language in the 14th Amendment to ban all types of discrimination, not just racial discrimination. So the draft of the 14th Amendment, initially agreed upon by the committee, said, and I quote, "No discrimination shall be made by any state or by the United States as to the civil rights of persons because of race, color, or condition of previous servitude." And their argument was, well, we're drafting the 14th Amendment to eliminate racial discrimination, so let's be specific about what we're talking about. We're talking about racial discrimination. However, Bingham said, no, the anti-discrimination language has to be broader. So what we end up with for the 14th Amendment, I'm just going to read the due process and equal protection clauses, because that's all I'm going to be talking about. "Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." So, like the Bill of Rights, the 14th Amendment came out of a revolutionary civil rights movement taking place during the Reconstruction era of American history. However, unfortunately, also like the Bill of Rights, the 14th Amendment entered its own period of dormancy because the Supreme Court badly misinterpreted it, and misinterpreted it so severely that the court largely crippled its transformative potential for decades after it had been ratified in 1868. So this very dangerous and damaging misreading of the 14th Amendment begins with civil rights cases in 1883, where the Supreme Court finds that Congress lacks the authority to ban segregation. In 1896, the Supreme Court finds that